Yes, so yesterday we discussed about corporate personality. We discussed about different advantages of the same. Okay, so there are different advantages of incorporation, and this law evolved out of common law, which and it has evolved over a long period of time. Okay, now obviously the same has been turned into legislations in different countries. So, what protections are available would also vary from legal systems to legal systems. So, yes, incorporation ensures separate corporate personality. It becomes a separate legal, entity. So, it has independent corporate existence, and that has some benefits. For example, there is, if it is a limited company, then there is limited liability. There is perpetual succession. Then the company's property is separate, so there is separate company property, not to be mixed with the property of, for example, shareholders. Now, this once the incorporation happens, the company has power capacity. The company has a power to sue and be sued. Okay, so there are so many advantages that come with incorporation. However, the advantages are for the corporation. Now the thing is, corporations are not real people like you and I. All humans have natural, personality that we have already discussed. We are natural humans. Okay, we are natural beings, and we have We are natural persons by virtue of that fact. Now, corporations are not the same thing. They are not real people. Okay. Obviously, corporations are created with this idea that they are advantageous to the people. Okay, they facilitate efficient transactions among people. But that's there. But what this entity, which has been created and has been given legal recognition to, is a separate entity, as we have discussed. And it can have lots of power, lots of clout. It can do lots of things that you and I as individuals are incapable of. Okay, although the same is not done by the corporation itself. Obviously it's managed by different people, but then because of so much concentration of wealth, power, they can do much more than we the individuals can, and that becomes a problem quite often. Very often it becomes a problem. In fact, sometimes it's possible that they have enormous control over the entire the political system. And it is also possible that democracy itself is compromised because there is lots of economic or money-based control that corporations have over the political discourse somewhere. It can create public opinion. So it has lots of power. Okay, and with the increasing development of science and technology, use of AI and all these other developments that are happening around you, you wouldn't even know how your mind's controlled. Okay, so these are not sci-fi issues anymore. Look at how Facebook has been able to influence politics in different countries, elections in different countries. So these are things that are to be taken seriously. Some countries are able to make them or hold them responsible. There are others who are not. So we have to be extremely careful. Now, those are larger issues that we will look into later on. But then let's start with certain, much simpler issues. Okay, certain other problems that we come across. Okay, when it might be necessary for us. Okay, so all those problems are problems. The other examples that I gave you are those situations where are the larger problems that we need to come across, and we need to find out ways of how to handle corporations. Okay, but then there are other situations where those who form the corporations, okay, they might use this separate corporate personality, this separate legal entity that corporation is, so as to get some advantages, okay, which are not legal, okay, which are very problematic, as we will see. In those situations, okay, it might be necessary to lift the corporate veil. Okay, so once the incorporation happens, we have seen, for example, in Solomon versus Solomon Limited, and then also Lee versus Lee's Air Farming Company Limited, that there's this idea of separate legal existence. Okay, so that means corporation has a separate personality, separate from that of individuals. Okay, but it is also possible that the same is done, the same is created for certain ulterior, with certain ulterior motive. Okay, which is not justifiable. So in those situations, it might be necessary to lift this corporate veil. Okay, so as to see who's really in charge there and what are they up to. And that's known as this doctrine of piercing or lifting corporate veil, to find the reality behind this corporate existence. Okay, now there could be many different grounds. Okay, some of them would be discussed, for example, whenever you study company law. You will be taught about the specifics there, so I will not go into all those details here, but I will have a look at some of the judicial grounds. So obviously the legislation can provide you various grounds when a director of a company or other employees of the company can be held liable. Those are definitely there. Okay, and that could vary because legislations might be enacted and then they can be amended. So those you will study in company law classes. But there are certain other more general grounds, okay, based on which this corporate veil has been pierced. Okay, and these are the things that you see in many different legal systems. So those are some of the things that are worth discussing here. Okay, so there are many judicial grounds, the grounds that judiciary thinks, okay, the judges, the court thinks are appropriate for lifting this corporate veil. Okay, so let's look at some of the cases and that will be able to clarify this for us. So for example, in the case of United States versus Milwaukee Refrigerator Transit Company, we'll type this case here. So in this particular case, the Supreme Court of the United States held that where the notion of legal entity, okay, is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will disregard the corporate entity and treat it as an association of persons, so as to impose liability on these persons who are in fact doing all these things under the pretext of them being separate from the corporate entity. Okay, in such case, if all these grounds are justified, then the judges quite often do lift the court quite often do lift the corporate veil to find out who's actually doing all these things. Otherwise, how do you punish the corporation? There is no one to punish there. It's fiction, isn't it? But situations might arise, as has been described here, okay, when it might be necessary to lift the corporate veil. Okay, so some of those grounds let's look at. Okay, so for example, when a corporation, okay, is created so as to commit fraud, okay, or so as to indulge in some inappropriate, improper, conduct, which will otherwise not be justifiable if it was done by, natural person. But this corporation, this company is created so as to do the same, okay, and to escape the liability, basically. So in such situation, the veil of this corporate veil is lifted. So one very important and famous case is by the name Guilford Motor Company versus Horn. Guilford Motor Company versus Horn. So in this particular case, what had happened was that one Mr. Horn, okay, was appointed as a managing director of this company, that is Guilford Motor Company Limited. But it was subject to some conditions, okay. And what was that? The condition was that he will not attempt to entice or solicit customers of the company while he is like an employee of the company, and even afterwards. Now what he had done, so this is something they agreed on, okay. So that was an agreement between the company and this guy, Mr. Horn. However, in order to escape from this, agreement, what he did was that he immediately afterwards he created a company, not in his own name, in the name of his wife, and then that company, basically carried out competing business, okay, with this particular company, that is Guilford Motor Company. And he was in management. Now, in this particular case, it is so clear that the same was done clearly to, get away from that obligation that he had of not soliciting or enticing customers of the Guilford Motor Company. So it was held in this particular case that this newfound company, okay, was merely a sham, a cloak, and hence Horn could not solicit company's customers. So you see, this is a clear case where the company was created to indulge in some improper, conduct. So yes, sham companies, when they are created, the veil is lifted. Another important, very famous case is by the name Jones versus Lippmann. In this particular case, what had happened was that a person, okay, that is a seller of a piece of land, okay, now he hadn't really, sold the land, okay, he had entered into a contract of sale. Now, contract of sale is not the same thing as sale. When the sale happens, the transfer is complete, whereas when there is a contract of sale, it's only a promise that in future the sale will be completed. So it's not a sale, but merely a contract of sale. Okay. So in this particular case, one, okay, who wanted to sell the piece of land, okay, sought to evade the specific performance of this contract of sale, okay, of the particular piece of land. And what did he do in order to evade? He basically formed another, company, okay, because, he wants to retain the, land in himself, okay. So what he did was that he created a company and then conveyed the land to that company. And this was done solely for the purpose of evading this specific performance of the contract. Thus, what he tried to do was he tried to avoid completing the sale, okay, which is the requirement under the contract of sale of that particular, land. Now, you see in this particular case, the company was created solely with the purpose of avoiding that obligation under the contract of sale. So in this particular case as well, Justice Russell described the company as a device and a sham and a mask which, he holds before his face and attempt to avoid recognition by the eye of equity, and thus ordered both the defendant and his company, okay, Lippmann here, to specifically perform the contract with the plaintiff. So even though there was a company which had purchased, and company is not the same as Mr. Lippmann, nonetheless, court held that, well, that's the same thing, okay, it was done solely so as to avoid performing the contract. So Mr. Lippmann was ordered to specifically perform the contract with that of plaintiff, that is Mr. Jones here. So I hope these are clear. Are these examples clear to you?
Yes, sir.
Yes, okay.
Yes, sir.
So you will study these in much greater detail later on in your company law. So I'm just, because these are related to the topics that we are discussing, so I'm introducing this, okay. Not an expert in all this. Now, well, that's not the only case when the same is lifted. Not just in the case of fraud and improper conduct. Not just when the company is a sham. Well, there are other reasons. Okay, so they broadly overlap, as you will see. Okay, quite often one may create a company in order to avoid having to pay taxes or reduce tax liabilities. Okay. So you know that you can avoid tax if you do it legally, but you cannot evade tax. That is, basically, you cannot avoid paying tax illegally. Otherwise, legally, you can distribute your assets in such a way so as to pay as little tax as possible. But as long as you are not breaking the law, not a problem. But there are so many ways and machinations that individuals use in order to avoid paying tax. So, and one of the ways of doing that could be through creating these sham companies. Okay, and how is that done? So, in a very famous case by the name Dinshaw Monikji Petty. Okay, in this particular case, what had happened was that this fella, he founded 4 private companies. Okay, 4 private companies were created, and so this guy had lots of income, okay, in the form of dividend from whatever he had invested in, and other interest-based income. Okay, and he did not want to pay taxes. So what he did, he created these 4 companies, okay, and all his income were credited to the account of these companies, but he needed the money. And how would he get the money? So the money was extended to him by these 4 companies as a loan, as a pretended loan. So that was not really real loan, because the companies were created by him only, okay. And because he got the money as a loan, that meant that he will be entitled to certain tax benefits. So in this particular case, you see these companies were created solely, to avoid, paying taxes. And these were sham companies. So in this particular case, it was held that the purpose behind founding these new companies was simple, as a means of avoiding tax. And hence, lifting of corporate veil here is justified. And there are other situations as well where the same could be done. So, for example, if the company has enemy character, so during war-like situations, okay, if the company is doing business here in India, for example, are of enemy character, then we have to find out whether they are really the companies of enemy character. And how do you do that? You cannot look at the company and then say that, well, the company is of enemy character. No one there. Okay. It seems like impersonal, okay, although it has legal personality. But how else can we do that? We have to lift the corporate veil and then see who all are really in charge, who are the dominant, shareholders, who are in the different controlling bodies. You have to find all that to ascertain the character of the company, the enemy character of the company. So you have to find persons who are in de facto control of the company. So, and this happened, okay, in a very famous case by the name Daimler Company Limited versus Continental Tire Limited. So, in this particular case, what had happened was that there was, that Daimler is a German company. It was a German company even then, okay. Now, it had created a subsidiary company in Britain, okay, and that subsidiary company, Daimler Company Limited, okay, entered into a contract with Continental Tire and Rubber Company Limited. And that's the British company, from Great Britain, okay. And the contract was supply of tires. Now, it was during wartime, okay. First World War. Okay, so because of the war times, the British company now, they realized that the other company they entered into contract with for supplying tire is of enemy nature. Okay, because of that, the British company refused to pay as this particular company, the other company, was an alien company, and that is prohibited during this wartime. Now, when the matter goes to the court has to find out the real nature of this other company with which Continental Tire entered into contract with. Okay, so to find out whether the company was really a British company or a German company, it had to lift the corporate veil, and then it found that the decision-making bodies, okay, the board of directors, general body of shareholders were all controlled by Germans. So in effect, although the company was in Britain, in effect the company was a German company and not really a British company, and hence it was a company of enemy nature. So it was an enemy company, and hence in these situations, lifting of corporate veil is justified. There could be other situations, okay, where a company tries to avoid legal actions, okay. In those situations as well, the same could be, the corporate veil could be lifted, and you can also find that for example, in the Companies Act 2013, many provisions are there where the same is allowed. But another very interesting situation where we see the company, this corporate veil is lifted is under this idea called single economic entity. Okay, when you hear about enterprises, okay, groups of enterprises, so they are not just one company, okay, they are multiple companies, and each company, when they're incorporated, the law says that they have separate legal existence, okay, because they are separate corporate personalities, so they have separate existence. However, quite often you will see that there is one company that asserts, that holds controlling, that holds lots of control over the other companies. So you may have holding companies, and then there are subsidiary companies. So look at Tata Sons being one such example, okay, and they have lots of other subsidiary companies. There are other such companies, okay, so there are holding companies that finance in other companies, basically retaining control over decision making of these subsidiary companies, okay. Depends on how much share they hold. You may also have to look at de facto control that the dominant company asserts on the subsidiary company. That is, the holding company asserts on the subsidiary company. So in such situation, the court might have to lift the corporate veil, okay, to ascertain the real control, the factual control which is exercised in order to identify the true nature of these companies. So one British case by the name DHN Food Products versus Tower Hamlets, okay, is a case where the corporate veil was lifted to check the factual control exercised. So there are many such cases. So for example, in LIC versus Escorts in India, just a second. LIC versus Escorts is an Indian case. In this particular case, the court said that the corporate veil may be lifted where the statute itself contemplates lifting the veil. So you have to look at the Companies Act, for example. Or fraud or improper conduct is intended to be prevented. Or a taxing statute or a beneficent statute is sought to be evaded. We have discussed all those. Or where the associated companies are inextricably connected as to be in reality part of one concern. So although because of incorporation they seem to have separate corporate existence, but in reality the companies are connected together, okay, and you have to then find out the real nature of these companies, okay, and then you may be able to find whether they are single economic entity or not. So it's a factual thing, okay. You have to look at who's exercising control here, who holds majority share, okay, who holds control over decision making, okay. All those things are decided. All those things have to be found out. So it's an empirical matter, obviously, which the courts have to do in order to find out the true nature of these companies. Now, especially in this thing, okay, so as you will see, the idea of separate, okay, corporate personality, okay, or separate legal entity that corporations are. That idea under the corporate, companies law comes in conflict with another idea, as we just discussed, that is single economic entity. Now, single economic entity is something that you will find under the competition laws, okay. So in different countries, I'm not an expert in all this, but just for the sake of your knowledge, in so competition law basically exists to promote fair, competition. Okay, so in capitalism, the idea is that different, companies will compete with each other, and they will sell their stuff for the list price, so that people are entitled to the benefit from this healthy competition. But it is possible that sometimes bigger companies with more money might acquire and then and basically have monopoly in the market. And if they have monopoly in the market, they will be the only company that will determine the quality of services, or objects, goods sold to you, and the benefits that you the price that you have to pay. Okay, so that is prevented. Competition law exists in order to prevent that from happening. Okay, so many things are prohibited. So especially in case of mergers and acquisitions, competition law becomes relevant for us. Okay, but even under the company laws, okay, this idea of single economic entity becomes relevant. Why? So in order to prevent anti-competitive practices, okay, certain measures are taken under the law. Okay, however, if the companies are single economic entity, in the sense that, okay, so there are holding companies and then there are subsidiary companies, and in effect they are really one enterprise. Okay, they are not to be treated as competing companies. The decision making happens from the center. In such case, even though the companies are different, they are treated as single economic entity. Okay, so that is also a case where you see a deviation from this idea of separate legal existence. But that is not really directly relevant here, because yes, that's done by the different bodies created under the competition law. So maybe the CCI is there and other bodies are there. They deal with that. But even the courts can do the same. Okay, they may lift the corporate veil in order to find out the true nature of the company, that is the single economic entity. So sometimes, for example, employee of one of those subsidiary companies can go against the holding company and seek a remedy for violation of certain rights. Okay, and in such case, although it seems to be that holding company has a separate legal existence, but in effect they are responsible, so they could be made responsible, and there are cases that you will come across. So that's the idea of single economic entity. That yes, so it's just like the negligence cases. Okay, so where principal is held liable for the agents. Okay, so in a similar way, here also you see that the holding company could also be held liable for the actions of the subsidiary companies. So, but separate corporate existence does not allow that. But the reality could be that these holding companies have substantive control, factual control, de facto control over the subsidiary companies. To identify that, the court might lift the corporate veil to find out whether they are single economic entity or not. Apart from that, if the company tries to avoid welfare legislation may provide benefit to the employees. Okay, so if the company tries to avoid the same, in such case also the same can corporate veil could be lifted for the sake of public policy as well. So those larger concerns, okay, for those larger concerns, this corporate veil might be lifted. Apart from all this, there could be statutory grounds as well. So for statutory grounds, you have to look at the companies law. Okay, so for example, the Companies Act 2013 will provide you the specific grounds for which during which individuals could be made liable and not the company. So that means you are lifting the corporate veil. So there could be many such examples, but I'm not going to go into all that. You will study that in your company law classes. Now, from here, let's proceed to something very interesting. Okay, interesting in the sense that, well, we have seen so far that companies are legal persons. They are juristic persons. Okay, and persons become entitled to fundamental rights. So which are the rights that will be available to companies? Now, one thing that we know is that companies, even though they are persons, okay, legal persons recognized by the law as persons, they are not citizens. Okay, so that tells us that those rights which are exclusively available to only citizens are not available to corporations. But there are other rights which are available to all persons. And in those situations, obviously, the protection would be available. Okay. So you have to look at the language of the fundamental rights. So, for example, Article 14 doesn't specify that the requirement of citizenship. Okay. However, Article 15 and Article 16 clearly talks about citizens. Okay. So Article 14 talks about equality before the law, that state shall not deny to any person, it says persons, not citizens, okay, to any person equality before the law or equal protection of the laws within the territory of India. So that's there. But if you look at Article 15, 16, the word is citizen there, okay. So that tells us the kind of protection that will be available to corporations. And what are those protections? So it can definitely, if unequal treatment's there, so it can definitely say that, well, there is a violation of, the fundamental right under Article 14. However, certain other rights, as I told you, 15, 16, or for that matter, the freedoms under Article 19 are for whom? Are for citizens. So those will not be available to companies, okay? Those are not available to companies. So that's something you should keep in mind. So this has been held in many different cases, okay? So for example, Excel where, etc. versus Union of India. Just a second, I will just share this cases with you. This is keep track of all these cases I'm sharing with you. So in this particular case, it had referred to, other cases have also been referred to. For example, in this particular case, it refers to another case by the name, the state of Gujarat, and another versus Ambika Mills, Ahmedabad. Okay, so we'll share all these cases with you. So in this particular case, just a second. So yes, in this particular case, it refers to this other case, and many other cases are there, okay. And it says, it was urged that even if there is a violation of impugned law of the fundamental rights guaranteed under 19(1)(g) and not saved by clause 6 thereof, the said right has been conferred only on the citizens of India and not upon the corporate bodies like company. It's there. So yes, 19(1)(f) will not be available as a fundamental right to the companies. However, one thing that we have to keep in mind is that company in reality is not a real natural person. It's a legal person. Okay. And obviously, a legal person should not be treated the same way as individual, that is, natural persons. But quite often, what happens to a company might also affect the fundamental rights of individuals. And for that reason, in order to protect the rights of individuals, indirectly it seems to be the case that some rights of the corporation have also been protected. Okay. So there are cases like Bennett Coleman Company and others versus Union of India versus and also the bank nationalization case, that is R.C. Cooper versus Union of India. It was held that if shareholders' right is impaired, the state cannot impair the right of the shareholders as well as of the company, and the court can strike down the law for violation of fundamental right guaranteed only to the citizens of the challenge. So, of the challenges by the company as well as by the shareholders. So anyway, so you see in these two particular cases, the opinion has been like this, that if it affects the citizens' fundamental rights, then it might interject. Okay, so that's the idea. However, the overall view is that in this particular case is that a shareholder is entitled to this in the bank nationalization case. It was said that a shareholder is entitled to protection of Article 19, that individual right is not lost by reason of the fact that he is a shareholder of the company. So in this instant case, it refers to the bank nationalization case and then says that the bank nationalization case has established the view that fundamental rights of the shareholders as citizens are not lost when they associate to form a company, when their fundamental rights as shareholders are impaired by state action of the rights of the shareholders are protected. The reason is that shareholders' rights are equally and necessarily affected by the rights of the affected if the rights of the company are affected. So, as I told you, indirectly protecting the rights of the company by virtue of direct protection of the fundamental rights of the shareholders. But that seems to be a case of going against the corporate, separate corporate existence, okay, separate, corporate personality that we just discussed. The idea of incorporation is that once incorporation happens, the company is separate from the individuals who created, okay, or the shareholders. But here it seems that the court is saying that, well, in reality, it's really the shareholders who are affected. Then are we not saying then that companies do not really have in reality have separate legal existence? That seems to be the conclusion that it has arrived at. So you will see that constitutional cases are not just legal; these are also political cases. So judges, ideologies, and all those factors definitely would matter here. Okay, all those factors, it has to be looked at from that political perspective as well to understand what's really going on here. Now, let me put my views here with respect to this matter. It is this that, see, companies are not people, okay? Companies exist for a certain purpose, okay? Companies, obviously, legally, many ethical limits can be imposed, but prime motive, okay, prime driver behind companies, okay, is to generate profit for investors, okay? That's the idea. And profit, whatever means they can use, okay? So as long as they are providing profit, well, that's fine. That's the purpose with which they exist. Now, so many legal constraints are imposed on them so that they do not refer to unethical practices for the sake of profit, okay? So that's there. Now, what we have to remember is that companies, as you see here, as has been opined here by Justice Ian Reyes, that, well, companies are really an association of people. But is that so? You will see quite often the shareholders do not really have any say in how the decisions are made. And then, if you look at the effective reality, you will see it's really the money, it's really the concentration of wealth that, matters, okay? And that leads to decisions being taken in a certain way, okay? So we have to be very chary, very careful about that, okay? When too much concentration of wealth happens, too much concentration of power happens, and that power is not just restricted to the business only. They will use that, wealth also to affect the political process in a particular country, effectively nullifying, okay, negating the democratic process in a particular country. And then when they have control over the political system can then be used to ensure that there is monopoly in the business of certain specific companies. And when that happens, you are effectively being ruled by certain companies. You are no longer under the rule of your political representatives that you have appointed to legislate and then rule over you. Okay, so that's negated, and this has not happened now. It has happened for a long time. Even the Greeks and Romans have experienced the same thing. Okay, and probably had happened even before that. This is the condition. Okay, so power has this tendency of concentrating. Okay, that's how power works. Do not look at the faces of the people. Look at it as a case of concentration of power. And that's what happens. It just wants more and more power. And that will have this effect of nullifying, negating Democracy is diffusion of power. Okay, it means power in the hands of the people, but that's not liked. So sometimes, an illusion of freedom might also be created so that you do not really see what the reality is. Okay, so you have to be extremely careful about all that. And in the age of science and technology, in the age of, so for example, lots of automation is happening. So earlier there used to be employees in the company, and they might in the not so distant future be replaced by AIs. So for example, I'm uploading my lectures. Why would this university need me in the next semester, okay, when it's all there on the internet? So if it were university's property, they may just, okay, but that's not how it happens here because of the protection that I have with respect to my job, okay. But you never know. In the not so distant future, everything works like that, okay, and then whatever protection you as an individual have can just vanish, okay, because there is too much power, influence, clout, which is concentrated in the hands of these, companies, and they affect, they influence policy making, they affect law making, and that essentially means that, well, we are no longer with any power. So we have to be very careful, very chary about that. Okay. So that means what? The crux of this whole idea is this, that companies cannot be treated the same way as we treat individuals. Okay. That is natural persons. Companies are not natural persons. They are legal persons. So only those protections should be given to companies that, they deserve, that can be provided legally. They are not to be treated the same way as individual humans are. However, you will see that in the United States, I'll first go to United States, then come back to India. Okay. In the United States, there has been a development. Okay. So, after the 14th Amendment, okay, the equality protection was extended to equal protection of law. That protection was extended to companies. Okay. Especially the railway companies as existed in the United States. Okay. However, so for a long time, the idea was that, well, only certain limited protections were available to companies, okay, corporations in the United States. However, recently, in the recent case by the name Citizens United versus FEC, I will just share the link, okay. I'm sorry, I will have to share well, I'll share a Britannica link with you. You will easily find it. Just type Citizens United versus Federal Election Commission. Okay. So in this particular case, okay, what had happened was that companies are now recognized as people. So effective idea is that companies are people. So in this particular case, the Supreme Court of the United States, by a 5-4, okay, judgment, okay, held that the First Amendment rights, okay, what are First Amendment rights? So basically, free speech rights, okay, are also available to companies. Okay, those rights are also available to companies. But in India, the Article 19 protections, rights are not available to companies. But in this particular case, for the first time, it held that, well, the view also existed in the conservative circle, that yes, corporations are people, companies are people. So you will see that in the United States, the Republican Party usually holds that view. Some even in the Democratic Party do basically, there are, okay, those who hold that view, but then those who are tilting towards the left, okay, are against this idea, okay. So when I say tilting towards the left, you are not to understand that as communists, okay, that's another extreme, okay, without commenting justification for the same, no, not that, okay. Those who basically believe truly in the idea of democracy, that yes, in democracy it's the individual humans who matter, okay, sentient beings who matter, okay, they should have the power. You have to be careful that when there's too much concentration of wealth in the hands of the company, well, they can have tremendous effect on the political decision making, effectively nullifying, negating democracy. So we have to be careful about that. However, in this particular case, Citizens United versus FEC, it's a 5-4 decision, and it held that the First Amendment, protection is also available to companies. So it extended the First Amendment protection to corporation, and that basically meant that the corporations have full right to spend their money as they wanted in whatever candidates in the elections, okay, whether it is federal, state, or local elections. So that decision had the effect of negating this idea that was held for a long time, that free speech is only for the natural persons. So this has been, according to me, a very problematic development in the United States. But one thing that you need to know about the United States, that there is a kind of transparency. Okay, so quite often you will hear that, well, so and so Senate or so and so whatever members of the Congress have been found by, for example, NRA, National Rifles Association, that they have, that talks about gun rights and all that, and they have all these problems with shooting. Still, they are not able to come up with regulating who gets to possess guns because of these clouds, because of all this money that corporations like NRA spends in politics. Okay, however, they are coming up with new law to regulate gun holding. Okay, so some psychological testing will be done to look at stability. Forget about banning possession of guns. Okay, now why is that possible when so many killings happening in the United States? Whereas look at Australia, due to one shooting, they banned and they have no shooting. And then hear about New Zealand. Okay, there was this shooting that happened in the mosque. Immediately after that, there was a consensus to ban, put control over possession of guns. And it was done through the political process. Why is it so difficult in the United States? Because of this cloud that these corporations have, okay, the money power that they have. They can basically buy all these politicians, buy their political views, buy their votes, effectively negating the opinion, the will of the public who have elected these people into power. And they don't have to do it directly by buying. They can also generate public opinion. Okay, so we have to be extremely careful about all this, okay, just to ensure that we do not go back to plutarchy. Okay, you don't want that. We are the common people. We have to think in terms of our own interests. So yeah. That's what's happening in the United States. But one thing that's good about the United States that cannot be denied is this, that they have transparency. So when you vote, you know who has funded the candidate you are voting for. Okay, so that's there in the United States. Now, what about India? So in India, you know that companies are not considered as citizens. They are persons, though legal juristic persons. So they are entitled to those protections which are available to juristic persons. However, we have also seen that indirect protection has also been given to companies by saying that, well, they are actually the association of people. But that's a problematic view, as I told you. Now, apart from that, there are certain other problems that exist in India, okay, similar to the problem that exists in the United States. So, although in India companies do not enjoy this free speech, guarantee under Article 19, okay, however, they definitely get to fund, political parties. They definitely have that, okay, and we have to be extremely careful about that. So, in India, we have corporate funding of elections. Earlier, there were certain restrictions on how much they could, pay. So, for example, under the 2013 Companies Act, certain limits were there. Okay, however, certain the restriction that was there was raised. So, under this legislation, the earlier limit of 5% was increased to 7.5% of the profit of the company. So now then, okay, until the Finance Act of 2017, thanks to Finance Minister, the then Finance Minister, Mr. Arun Jaitley. Now, before that, okay, there was a 7.5% cap on the percentage of net average profit that could be in the preceding 3 years that could be basically used for political parties. Okay. However, by virtue of this Finance Act, they raised this. They basically removed this limit. Okay. Now, whatever amount they want to, they can. Now, what happens? The outcome of it. I'm being political here, but there's no way that I can escape this. The thing is this: when government has a lot of power, they can use that power to wrest the companies into. It doesn't have to do that directly. It has enough mechanisms in its hand to ensure that political parties donate to your party. Apart from that, and then you see the problem is like this, and the more money they have, the more influence that they will have. Okay, so that's what actually happens. And apart from that, and earlier there was also this limit that the restriction that foreign companies in India cannot make such contributions. But changes were also made to Foreign Contribution Regulation Act 2010 FCRA. Okay, by virtue of 2018 Finance Bill, and that allows companies, even though they are from outside, if they are registered in India, to make political donations. So, and apart from that, there was this electoral trust that already existed, which in itself is problematic. But then Mr. Jaitley also introduced electoral bonds, and you can now make anonymous donations. So through all these ways, you see that the political process is degenerated. And if you look at the trend, okay, if you look at the data from Association for Democratic Reforms, you see that most of the fundings have gone to the party which is in power, that is BJP. So, and when one party has more funding than others, okay, then they will definitely have much more control over this entire electoral system. Okay, so we have to be extremely careful, despite ideological differences. You never know tomorrow which party comes to power, and they will use this same illicit, from a democratic perspective, this same illicit, maybe not legally, laws are enacted, but illicit from a democratic perspective, and they can use the same mechanisms in order to negate and nullify democracy. One thing that we have to keep in mind is that power has this tendency of concentrating, okay, and more power is concentrated, more it will try to concentrate power, and that will definitely have the effect of nullifying democracy. And democracy involves diffusion of power. Okay. It empowers everyone. So no matter where in the political spectrum of political ideology we stand, we have this necessity as the citizens of this country to speak for democracy and speak against any centralizing tendencies. Now, yes, now here's the difference. So unlike in the United States, in India, even though free speech right is not recognized for companies, but there are enough avenues which are there which can basically ensure that they exercise more rights than the individuals, especially in these political matters. Okay, that happens. And there is also lack of transparency because of introduction of this electoral bonds. So it's up to us now as to what to do about it. So these are some of the problems that I thought as I noticed, and should definitely be brought to your notice as well, so that you have a better understanding. Now you get to process and then think about the problems according to your own self. So yes, so the difference is that in India, at least in theory, corporations do not have free speech or other freedoms under Article 19, but what is the reality? So we have to look into all that. So that's it when it comes to corporate personality. Okay, so in the next class, we are going to discuss about some of the theories of corporate personality. It's going to be a very small topic. And then we are going to start law of property. So that's it from today, from me for today. So any